Hello, my name is Elliot Stapleton, and I'm here to discuss a financial power of attorney, also known as a durable power of attorney. So what this is addressing is if you have been named as someone's agent to take action on their behalf if they are incapacitated, in a coma, or no longer legally competent. So I'm going to go over these considerations and how to address them. So the first item is the document itself, a financial power of attorney. This is also sometimes called a durable power of attorney, but specifically you're addressing financial decisions for the person who is incapacitated. So this is an agency role, meaning you are acting on their behalf, looking out for their interests. The benefit to having this document in place is that it avoids a guardianship. If unfortunately a person becomes incapacitated, is no longer legally competent, and doesn't have a power of attorney named, they would actually, their family would have to open a guardianship proceeding in probate court to act on their behalf. And a guardianship proceeding, while effective, is not as effective as a financial power of attorney and costs thousands of dollars extra because you have to file with the court, continue to file all of the transactions with the court, and there's quite a lot of extra work, whereas with the financial power of attorney, all of that documentation can happen outside of the guardianship proceeding and is much easier to maintain. So when is this power effective? You might have been named in someone's documents, but that power, meaning when you can act on their behalf, could vary. It might be an immediate power, and it might be a springing power. So an immediate power means that right after the person signs it, you can act on their behalf. You could sign documents. You'd always have to, of course, check with them if they're still competent on those transactions. And ultimately, all transactions have to be within the best interest of the person for whom you are acting. The power might also be springing, meaning it's not effective until it springs into action. And the way it could spring into action is if a court determines a person is no longer legally competent, or physicians confirm that a person is no longer able to make their own decisions. In some cases, it may be that a person has diminished capacity, but refuses to accept it. In that case, of course, the immediate power is much better because it allows you to step up and take action on behalf of the person to protect their own interests, especially if they are not aware they have limited capacity. If the power is springing, you would have to then take them to court to have the court confirm that they are no longer legally competent, assuming they refuse to see a doctor. But the key is to, if you feel the person in whose document you've been named has limited capacity or has making decisions that are not clear and seem to be against their own interest, talk to them, communicate with them, and try to get them to see a doctor. If they refuse to do so, then you would, of course, need to take action to protect them from themselves. One important component of this document, aside from most others, is that it's very important to have an original. Typically, the law firm maintains the original, but not always. In some cases, the client prefers to maintain it. The reason this is important is if you don't have the original and you need to transfer real estate, you can't do it because the original financial power of attorney has to be recorded. And there are other instances where it's very helpful to have the original, but the key is to locate it and secure it and confirm with the law firm that they have it secured. The other consideration, one that's pretty common for people to misunderstand, because you may be acting as the power of attorney in some cases for years. If a person has Alzheimer's or dementia, the key to remember is that at death, power is over. At that point, the power of attorney ceases to exist and cannot take any action. At the point of death, these documents might apply. So the trust, if the person has a trust, related to the assets that are actually in the trust, or a will, if that's all the person has, which would be the assets passing through probate. But the key is that at death, the financial power of attorney no longer applies. So that covers key elements. If you've been named as an agent in someone's financial power of attorney or durable power of attorney, as always, it's best to seek legal counsel before actually taking action. And I hope this information was helpful. Thank you.